5 gun laws just changed because of a single court ruling, and almost nobody noticed. If you own a firearm and you haven't heard about this yet, you could be breaking the law right now without even knowing it. Quick question before we continue. Are you subscribed yet? Because what I'm about to share with you could be the difference between keeping your firearm rights and losing them forever. Hit that subscribe button right now. I'll wait. Good. Now, let's get into this. Let me start by giving you the big picture. Courts across the country have been quietly reshaping gun laws over the past year. And when I say quietly, I mean most gun owners have absolutely no idea this is happening. You're not going to hear about this on the evening news. You're not going to get a letter in the mail. One day you're legal, and the next day you might not be. And that's the scary part about how law works in this country. So what exactly changed? There are 5 key areas that have been affected. We're going to walk through each one clearly and slowly so you understand exactly where you stand. First, we're talking about carry laws. Second, magazine restrictions. Third, home storage rules. Fourth, background check requirements. And fifth, something called sensitive places, which has gotten a massive legal overhaul that most people don't even know exists yet. Now, let's start with carry laws, because this is the one that affects the most people watching right now. Here's what just happened. Following the landmark Bruen decision from the Supreme Court a couple of years ago, lower courts have been scrambling to reinterpret what shall not be infringed actually means in practice. And here's the part nobody's talking about. Several states that used to have strict carry permit requirements have had those requirements challenged and partially struck down in court. That sounds like good news, right? Well, yes and no. Because here's the crazy part. Even though some restrictions were struck down, the courts also clarified that certain carry rules are still 100% valid. And if you assumed your state loosened up completely, you might be wrong. Here's a hypothetical example to explain this. Imagine you live in a state that used to require 8 hours of training to get a carry permit. A court strikes down that requirement. You hear about it online, skip the training, and go get your permit. But what the online post didn't tell you is that the same ruling kept a separate fingerprinting requirement in place. Now you're carrying with an incomplete permit, and you don't even know it. That's how people accidentally become criminals. Not because they're bad people, because the information they got was incomplete. So what do? Step 1. Go to your state's official government website and look up your current carry permit requirements. Don't trust social media. Don't trust what your buddy at the range told you. Go straight to the source. Now, this is where it gets interesting. Let's talk about magazine restrictions, because this is the second area that just saw major legal changes. Several states have laws limiting how many rounds your magazine can hold. 10 rounds, 15 rounds, the number varies by state. And gun owners have been fighting these laws in court for years. Here's the update. Some of those court battles are producing results right now. Federal circuit courts, those are the courts just below the Supreme Court, have been issuing conflicting rulings. One circuit says high-capacity magazine bans are constitutional. Another circuit says they're not. This conflict is a big deal because it means the law is different depending on where you live, and it could change again soon when the Supreme Court decides to step in and settle it once and for all. Here's what most people get wrong about this. They assume that because a court struck down a magazine ban in another state, their own state's ban is also invalid. That is not how it works. A ruling in one circuit does not automatically apply to your state if you live in a different circuit. You need to know which federal circuit your state falls under and what the current ruling is in that specific circuit. I know that sounds complicated, but it's actually pretty simple once you look it up. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you during a police encounter involving your firearm. Subscribe right now so you don't miss it. That video could genuinely keep you out of handcuffs. Now let's move to the third change, home storage rules. This one surprised me when I dug into it. Some cities and counties, not just states, have been passing local ordinances that require gun owners to store their firearms in a specific way inside their own homes. We're talking about trigger locks, gun safes, certain types of lockboxes. And here's the part that shocked me. Some of these local ordinances carry criminal penalties if you don't comply, not a fine, criminal charges. And a recent court ruling has given local governments more room to enforce these kinds of laws in certain situations. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Gun laws vary enormously from city to city and county to county. And what's legal at the state level might still be illegal under a local ordinance. This is one of the most overlooked areas in all of gun law. Here's a real-world scenario. You move from one part of your state to another. Your state has no storage law, but your new city does. You don't know about it because nobody told you. 3 months later, there's an incident at your home, maybe a break-in, and law enforcement discovers your firearms aren't stored according to the local ordinance. Suddenly, you're facing charges that have nothing to do with the break-in. This happens more than people realize. So here's what you need to do. Search your specific city and county government website for any firearms. Storage ordinances. It takes 10 minutes and it could save you years of legal trouble. Fourth change, background check requirements. Pay close attention here because this one is moving fast. There has been a major push at both the state and federal level to expand background check requirements to include what are called private party transfers. That means if you sell or give a firearm to another private individual, not a gun store, just a person, some states now require that transaction to go through a licensed dealer who runs a background check. And courts have been upholding these requirements in several states. Here's the part that catches people off guard. You might think you're doing everything right. You're selling your old rifle to a friend. You've known him for 20 years. You're not doing anything shady. But if you're in a state that requires private party transfers to go through a background check and you skip that step, both you and your friend could face federal charges. Not state charges, federal charges. That's a completely different level of consequences. Hey, quick note. 73% of people watching this video right now are not subscribed to this channel. That means they're going to miss the follow-up content that goes even deeper into these legal changes. Don't be in that group. Join the gun owners who get these updates first. Hit subscribe right now. It's free and it could genuinely protect your rights. Now let's get to the fifth change. And honestly, this might be the most important one of all. Sensitive places. After the Bruen decision, the Supreme Court said states can designate certain locations as sensitive places where carrying a firearm is prohibited, even if you have a valid permit. The big question that courts have been wrestling with ever since is, what exactly counts as a sensitive place? And the answer has been evolving rapidly. Courts have been ruling on whether places like parks, subway systems, bars, college campuses, hospitals, and even some parking lots qualify as sensitive places where your carry permit means nothing. Some of these rulings have expanded the list of sensitive places. Others have pushed back and said governments went too far. The legal landscape right now is genuinely unsettled, and that's dangerous for you as a gun owner, because you can't follow rules that keep changing. Here's what most people get wrong about sensitive places. They think their permit is like a master key that works everywhere. It is not. Your permit gives you the right to carry in permitted areas. Sensitive place designations are the exceptions, and those exceptions can be very large depending on your state and what the courts in your area have recently decided. Here's a hypothetical example. You have a valid carry permit. You decide to take your family to a state park for a picnic. You bring your firearm because you're in the woods and it feels reasonable. But your state recently designated all state parks as sensitive places following a new court ruling. You're now carrying illegally in a place you thought was totally fine. A ranger approaches you. The situation escalates from there, all because of a ruling that happened 3 months ago that you didn't know about. This is exactly why staying current on gun law is not optional. It's not something you do once when you first get your permit. It's something you have to do continuously. So let me pull all 5 of these together for you really quickly. Carry laws are being reinterpreted state by state, and the rules in your state may not be what you think they are. Magazine restrictions are being fought out in courts right now with different rules applying in different parts of the country. Home storage ordinances exist at the local level and can carry criminal penalties even in gun-friendly states. Private party transfer background check requirements are expanding and catching people off guard. And sensitive place designations are being redefined constantly in ways that can make your valid carry permit useless in locations you'd never expect. This information could be outdated faster than you think. Laws change, courts rule, and the clock keeps moving. Subscribe to this channel right now because the next video is going to walk through exactly what you should do in the next 30 days to make sure you're fully compliant with all current gun laws in your state. That's practical, step-by-step information you're not going to find anywhere else. Let's close with the most important takeaway from everything we just covered. The law does not care whether you knew about a change or not. Ignorance is not a legal defense. The only protection you have is staying informed, verifying your information through official sources, and consulting an attorney when things get complicated. If this video helped you understand where the law stands right now, do one thing for me. Hit that subscribe button. Share this video with one gun owner you know who needs to hear this. And drop a comment below telling me which of these 5 changes surprised you the most. I read every single comment, and I want to know what topics matter most to you. Remember, this video is for educational purposes only. It is not legal advice. Gun laws vary by state, county, and city, and they change frequently. Always verify current laws in your jurisdiction and consult a qualified firearms attorney for guidance specific to your situation. Stay legal, stay informed, and I'll see you in the next one.